Good morning and a very warm welcome to the fourth and final in the series of St John's Chambers Wills and Trusts webinar series. So for those of you who don't know me, I'm Matthew Evans. I'm a partner in Hugh James here in Cardiff, specialising in contested wills, trusts and estates. We've had the pleasure of working closely with many members of St John's for many years now. We've four very interesting presentations today, which will be highly relevant for both contentious and non-contentious private client practitioners. Before we get started, there are just a few items of housekeeping. Firstly, this webinar is intended to be interactive, so please do feel to raise questions via the chat function, which you'll find on the toolbar that appears on your screen if you hover your cursor over it. It's the two speech bubbles with question marks. Your questions will then be picked up in a Q&A session following the last speaker at the end. We shan't be reading out your names, just the questions, so please don't be shy. Secondly, your feedback will be greatly valued and appreciated, so please do provide that either via the chat function or in the email that will be sent immediately after the webinar. Thirdly and importantly, notes and a recording of the webinar will be circulated via email after the webinar is finished, so please don't feel that you have to sit there and try and scribble down your own notes. That's all the housekeeping over with, and so without further ado, I shall pass you over to our first speaker, who is Mr. John Dickinson, who will be talking to us about how to deal with potentially insolvent estates. Over to you, John. Thank you.
John, you're muted at the moment.
Sorry about that. Matthew, thank you very much indeed for that introduction, and good morning everyone, and thank you for joining us. I'm going to be talking about how to deal with potentially insolvent estates, and the reason that's relevant, I'd suggest, for all of us, is that a state may appear to be solvent, and then a significant asset could disappear through a proprietary estoppel claim, something like that, or significant liabilities may emerge, and then we're in the regime of insolvency. I'm going to give you an overview of the insolvency regime for deceased persons and then talk about some case law which highlights some steps you can take to protect yourself. Oh, sorry, I've gone through the insolvency regime for the estates of deceased persons, that's dealt with in section 421 of the Insolvency Act. And if you want some guidance in this area, then Tolley's Insolvency Law Service is very helpful. It's Division D. What is insolvency? Well, this is provided for in section 4214 of the Insolvency Act 1986. An estate is insolvent if, when realised, it will be insufficient to meet in full all the debts and other liabilities to which it is subject. And you see from this definition that insolvency is when liabilities exceed assets. There's no definition of insolvency on a cash flow basis that the estate's unable to pay the debts as and when they fall due. The insolvency regime, well, it's section 4211 that gives the jurisdiction to set out a statutory instrument to provide the Insolvency Act 1986 how it applies with suitable modifications to the estate of a deceased person. And that statutory instrument is the Administration of Insolvent Estates of Deceased Persons Order 1986. That order has 6 articles and 3 schedules, and it's the schedules that apply the 1986 Act provisions. It chooses which set provisions to apply and with what modifications. And when you come to the rules that you need to be aware of, then they're set out in this statutory instrument, the Insolvency Miscellaneous Amendments Regulations 2017. There are 3 ways of administering an insolvent estate. Firstly, there's administration in bankruptcy. Secondly, administration otherwise than in bankruptcy. And thirdly, the continuation of a pre-death petition. So firstly, administration in bankruptcy. Well, that's dealt with in Article 3 of the order. And this is where a person's died before the presentation of a bankruptcy petition. The court process begins with an insolvency administration petition that seeks an insolvency administration order. The appropriate court is where the debtor resided. There's no requirement to serve a statutory demand. There's no requirement to show unsatisfied execution of a judgment. It's relevant to note that the personal representative may present a petition and that the debts must have existed at the date of death. So that means that funeral costs won't be covered, and administration expenses won't be suitable for founding a petition. The estate then vests in the official receiver as the trustee in bankruptcy. There's no provision for the discharge of the bankruptcy, so the bankruptcy will continue unless the bankruptcy is annulled. And the estate must answer for all the debts of the bankruptcy. There's no concept in this regime of provable and non-provable debts. Article 4 deals with the administration of the estate otherwise than in bankruptcy, and this means that the court process doesn't have to be used, and typically be the personal representative who administers the estate. Most of the provisions of the apply in the same way as administration in bankruptcy. Okay, next slide please, Hannah. And that applies under section Article 4.1, which applies the law of bankruptcy. Okay, next slide, please, Hannah. And the third way of administering the estate is a continuation of a pre-death petition. This applies where a person's died after presentation of a bankruptcy petition, and then the pre-existing court proceedings continue as if the debtor was still alive, unless the court orders otherwise. Next slide, please, Hannah. Those three methods of administering the estate were dealt with in paragraph 10 of the judgment of Mr. Justice David Richards in the Berylowski case. And that was a case where Mr. Berylowski died owing £40 million. He had been a very wealthy man, but when you're wealthy and things go wrong, you tend to end up owing a lot of money, and he had other problems as well. Okay, next slide, please, Hannah. The issue in that Berezovsky case, also referred as the Elenin case, was identifying the date at which to value the claims against the estate for the purposes of the currency conversion. And what the court held was that the date was the date of death, not the date of the Insolvency Administration order. And that was because the 1986 Act applies through the order to relate back various provisions to the date of death rather than the order of the court. Okay, next slide, please, Hannah. Just as an overview of the principles of insolvency here, there's what's referred to as pari passu. That's the equal distribution of the estate between the different creditors. To achieve this, there are adjustments of prior transactions to recover assets that have been put beyond the reach of the creditors. And that's through transactions of an undervalue being challenged, preferences, extortionate credit transactions, and liens over books and records. Okay, next slide, please, Hannah. During the administration of an estate, section 2841 applies to relate to restrictions on the dispositions of property. And the crucial thing, as set out in the slide, the provisions of section 2841, the crucial thing to take away from this section is that dispositions of property that take place between the death of the deceased and the insolvency order are void unless the court's given consent for those dispositions or the court has subsequently ratified them. Okay, next slide, please, Hannah. Section 2841 has retrospective effect. It applies as though the petition had been presented and the insolvency administration order made as at the date of death. And those modified provisions retrospectively catch dispositions that may have been made by a personal representative when there was no issue about insolvency at all. Okay, next slide, please, Hannah. Thank you. There's limited protection. Section 2844 of the Act applies to transactions and dispositions made in good faith for value and without notice, but that only applies up to the date of death, not to transactions after death and up to the time of the insolvency order. Next slide, please, Hannah. Then the section 2715, that doesn't provide any saving here. Section 271 subparagraph 5 relates to payments made in good faith by the personal representative before the date of an insolvency administration order, but the sections that applies to doesn't include section 284, so that doesn't help us here. Next slide, please, Hannah. That takes me on to the case of Re Voss. Now, Mr. Voss was an individual who had been a Lloyd's name. He died in 1992. His son was the executor, and the son appointed DJ Freeman as solicitors. And he chose that firm because they were experts in Lloyd's litigation, Lloyd's insurance market, and they knew that there were claims coming. There was hard-fought negotiation for 6 years. Then Lloyd's issued a claim which DJ Freeman fought hard, and Lloyd's won on summary judgment. Then Lloyd's presented a position for bankruptcy, and that was fought as well and lost. The state was made bankrupt, the trustee in bankruptcy appointed, and they sought to recover all of the legal fees over the last 8 years paid to DJ Freeman. And what Chief Registrar Barrister held was that, firstly, in terms of the timing, applying a purposive construction to Section 284, it renders all dispositions automatically void. The retrospective effect doesn't engage the Human Rights Act 1998, its provisions in relation to the expropriation of property. Next slide, please, Hannah. And then DJ Freeman sought ratification of the payments to them of the legal fees, and the court only ratified the payments up to the time that the solicitor should have realised that there was a risk of the estate being insolvent. And the judge said that the solicitors had to be careful about incurring further expenditure without first seeking the approval of the court under a Beddoes type application. Next slide, please. The judge pointed out that the pari passu rule favouring the equal treatment of creditors supported refusing ratification of transactions after the solicitors should have realised that the estate may be insolvent, and the delay in seeking ratification had made it difficult for the court to assess whether transactions had really been made for the benefit of the estate. Next slide, please, Hannah. The judge gave some guidance as to the proper approach when an estate may be insolvent. He said that once the estate may be insolvent, the personal representative should administer the estate as though it were insolvent. The estate is held in trust for the general body of creditors and the beneficiaries, and this means that tactical commercial negotiations with creditors will no longer be possible. Each creditor should receive their entitlement under the statutory regime. Next slide, please, Hannah. Now moving on to the Jimmy Savile set of cases. Jimmy Savile was a TV presenter and celebrity. He died in October 2011, and in October 2012 a TV programme aired showing historic sexual abuse. Many claimants came forward against the estate, and the bank, which was the professional personal representative, was concerned that there may be insolvency of what had been a £3 million estate, and sought retrospective validation of its legal fees, £70,000 funeral costs, and IHT payments and other tax payments. And what the court held, Mr. Justice Sales, was that it would validate the very expensive funeral at Leeds Cathedral, because at that time there had been no question of insolvency. And it also validated the legal costs, but subject to specific wording that allowed a later taxation of those sums, and approved the IHT. Next slide, please, Hannah. The next case, a year later, there was an application by the trust, which was the ultimate beneficiary of Mr. Savile's, a trust charity, which was the ultimate beneficiary of Mr. Savile's estate, to dismiss the bank as executor because they said that the bank hadn't taken enough steps to actively oppose the claims. And that was dismissed by the judge, rightly holding that the creditor's interest needed to be taken into account. The court approved a scheme put forward by the bank executor to assess the value of the PI claims, and it made a validation order set under Section 2841 for the ordinary costs of administering that scheme and setting it up. Next slide, please, Hannah. And then that decision was taken to the Court of Appeal in 2014, and the Court of Appeal upheld Mr. Justice Sales' decision. It held that the Court of Appeal explained that not all expenditure has to be authorised in advance, and the Re Voss case isn't authority for that proposition. And the Court of Appeal particularly pointed to the fact that the scheme had been agreed with the personal injury claimants, and they would be the main bulk of the creditors, and their approval made the validation appropriate. Okay, next slide, please, Hannah. And that leads me to the last case of Re Studdert, and I'll run through this quickly because I appreciate I'm over my time here already. This was a decision of Chief Master Marsh at 31st of July of this year. Mr. Studdert died with an estate of £4.7 million. he was a paedophile and he'd been convicted of offences of having possession of indecent images of children. And the professional personal representatives were very concerned that there may be claims against the estate, and it wanted that though nobody had come forward, and it wanted guidance from the court. And Chief Master Marsh said that his judgment should be publicly available to help personal representatives deal with this situation. Next slide, please, Hannah. And so paragraph 19, he set out these statements of principles that the duty placed on administrators to pay debts and liabilities is not an absolute one. The administrators need to take reasonable steps to locate and identify unascertained creditors. The steps that the administrators need to take will depend on the circumstances, and the court will need to balance the reasonable expectation of the beneficiaries in with that. Next slide, please, Hannah. And what the court did in this situation was it barred distribution. It made provision for notification of different organisations Mr. Studdert had worked for, so that they could, with orders of disclosure, so that the personal representatives could find out if there might be claims. And it made provisions for setting up of websites in various different languages of countries that Mr. Studdert had contact with, in order to facilitate potential claimants coming forward against the estate and contacting the executors. So what I'd like you to take forward from this talk, if that's all right, is two things if you're involved in a potentially insolvent estate. Firstly, go to court and get ratification of what you've already done, the expenditure, and to give consent to future expenditure. And secondly, your relationship with creditors will be completely different. They're no longer the enemy. You're holding the estate on their behalf, and you need to look after all their interests. Thank you very much indeed. I'm sorry for the technical difficulties, and thank you for bearing with me. I'll now hand over to Charlie.
Good morning, everyone. Thank you very much indeed, John. Well, Wales and Dixon was very nearly an all St John's affair, because I represented the claimant executors in that case. Jodie Atkinson represented the 1st to 7th defendants, and unfortunately we let the second group of defendants make the mistake of being represented by counsel from another chambers. However, it was an interesting case that served to do two things. Firstly, to remind us of the principles relating to the interpretation of wills, and secondly, about the potential mistakes that can arise from bad grammar. Now, I think I am struggling to move the slides forward. So, Hannah, would you mind doing the same thing for me as you're doing for John? Thank you, I'm very grateful. So the claim was brought by the executors following a dispute between the beneficiaries or possible beneficiaries under the will of the deceased. The dispute related to the construction of the will of Mr. Peter Wales, who had been long married to Wendy, who had predeceased him. And in particular, the dispute was as to the proper interpretation of a clause in the will. And if I may, I'm going to read the entirety of clause 7, because it will give you some sense of the difficulties that arose, not only in terms of interpretation of the clause itself, but also generally from the standard of drafting in the will. So what this clause said was as follows: I give my residuary estate to such all of my nephews and nieces' children living at my death, subject to each attaining 18 years of age, and while any beneficiary hereunder is under such age, the income thereof shall be accumulated or applied wholly in part or in part by my trustees in their absolute discretion from time to time for his or her maintenance, education or benefit, which shall be held in equal shares, and if any or all of my nephews and nieces' children shall fail to obtain a vested interest, leaving issue who survive me and reach the age of 18 years, then such issue shall take, and if more than one in equal shares, their parents failed share. Now, if you found that slightly exhausting to listen to, if you saw it in the flesh, as it were, you'd be slightly exhausted by the grammar and the total absence of any punctuation whatsoever. But the critical problem, moving on to the next slide, if we could, Hannah, was, as I suggested in the last slide with the arrows, the humble apostrophe and the placement of the humble apostrophe. You'll have noted that the apostrophes sat inside the S. Now, why was that a problem? Well, that was a problem because, as you can see from the slide, the deceased had 2 blood nephews, 2 blood nieces, and so by that I mean children of his brothers or sisters. But he also had 3 nephews by marriage, that is, nephews of his wife's brother or sister, and a niece by marriage. As a result of that, the 1st to 7th defendants, who were the blood nephews and nieces, said that they were the ones who were entitled to benefit under clause 7 of the will, and the 8th to 15th defendants, the 3rd set, said that they were, as nieces and nephews by marriage, also entitled to benefit under the terms of the will. Now, in truth, the position of the humble apostrophe was easily resolved because of the fact that there were more than one nephew and niece by the blood. It was accepted that the will meant one of 2 things: either the blood nieces and nephews benefited, or the blood nieces and nephews benefited as well as the niece by marriage and the nephews by marriage. However, they couldn't agree amongst themselves which of those 2 options it was going to be, so off they went to the High Court to have the issue decided for them. Hannah, could we move on to the next slide, please? The judge then set out in his judgment the classic case of Marley and Rawlings. That's a Supreme Court case of 2014, and it's one that those involved in wills and trust litigation will be reasonably familiar with. But just as a reminder, it was a case in which the husband and wife had accidentally signed each other's wills. And one of the questions for the Supreme Court was whether the will could be interpreted so as to be the will of the correct testator. And if it was found, if that was found not to be the case, then whether a claim for rectification could probably be made. Now, as it turned out, the interpretation aspect of the claim failed, but the rectification aspect succeeded. But in rejecting the arguments in relation to interpretation, Lord Neuberger set out the principles that you can see there on the slide. And you'll note in particular in the first part of that slide that he refers to reference to the ordinary and natural meaning of words, i.e. those words used in the will, the overall purpose of the will, and the facts known or assumed, i.e. the background. Now, keen followers of the law on the interpretation of contract will note that the principles are very similar to those that relate to the construction of a normal contract. And in fact, Lord Neuberger said just that at paragraph 23 of his judgment. Could you move on to the next slide, please, Hannah? But he also made reference to section 21 of the Administration of Justice Act 1982, which he said must be considered in the interpretation of wills. And in my view, the section may not add a great deal to the common law principles, but it does emphasise the importance of the surrounding circumstances and that direct evidence of the testator's intentions is admissible. And in fact, what Lord Neuberger again said at paragraph 25 of his speech in Marley was that section 21 confirms the interpretation rules that apply to a contract also apply to a will. And then moving on again, please, Hannah. One of the specific cases that was referred to in the judgment was that of Redaust, if I'm pronouncing that correctly. That was a 1944 judgment of Mr. Justice Vasey, and he said that that case gave him some assistance because it dealt very specifically with the difficulty of the potential meaning of niece and nephew. And that difficulty arises because the old or traditional meaning of niece or nephew meant of the blood. So in this case, if one applied the traditional or old meaning, it would mean only the nieces and nephews of one's brother or sister, the testator's brother or sister, would benefit. However, Mr. Justice Vasey also held that the traditional meaning was capable of extension, having regard to the circumstances of the case and the broader context, so that it may encompass the children of one's spouse's brother or sister. In fact, he also went a step further and said that in certain circumstances, niece might mean, for instance, the wife of a nephew. Next slide, please, Hannah. So those are the principles that apply in relation to the construction of a will. And as I've said, they're very similar to those that apply to contractual interpretation. But of course, there are things that can't be taken into account. And there was an interesting element to this case, which was that a discretionary trust had been set up after the will was executed. And the beneficiaries of that trust were the children of the nephews and nieces of Peter Wales and his deceased spouse, Wendy Wales, either living or yet to be born. Now, the judge quite rightly held that that could not be used as an aid to construction of the will, couldn't properly be adduced as evidence, because it was a document that was created after the execution of the will. And he also said, quite rightly in my view, it could be interpreted either way, because he may have been, the testator that is, trying to benefit those that didn't benefit under the terms of the will, i.e. his nieces and nephews, the nieces and nephews of his spouse. Alternatively, it could be interpreted as reflecting the terms of the will. So it could be interpreted either way is the point. Moving on to the next slide, please, Hannah. Looking at the decision, the context and circumstances were plainly critical, and the key issues were the 46-year marriage, the prior wills, which formed part of the background, which made gifts to the wider family, including nieces and nephews of the spouse, the fact that the deceased had inherited the whole of the wife's estate, the fact that there was no extrinsic evidence intended to exclude the wife's children, and the fact, and I think this was probably of particular weight, the fact that there had been ongoing personal contact between the deceased and the wife's family after the wife's death, and in particular the children of her nieces and nephews. And so the judge found, in concluding, that it was both sets of nieces and nephews who should benefit under the terms of the will, not only those of the blood, but also those nieces and nephews by marriage. Moving on to the next slide. So, in conclusion, I recommend the judgment. There are some lovely uses of chancery language in there. Co-sanguinity was a new one on me, and he managed to get that one in. And there was also some wonderfully withering remarks made about the drafting of the will, which you might not be surprised about, given that clause 7 that I read out earlier. And I've set out some of those remarks there. And there are certainly, I think, some salutary lessons to be learnt about the drafting of wills. A focus on grammar is plainly one of them, and precision in execution. But of course, one can also take from the judgment that the interpretation of a will can be a wide exercise involving all the circumstances, all the relevant circumstances of the testator, in particular his relationship with the beneficiaries or the alleged beneficiaries. And of course, one can take into consideration prior wills, and even, although this wasn't the case in Wales and Dickinson, other ways of leaving money or assets to beneficiaries, such as trusts, as long as they were created prior to the will. Last slide, please, Hannah. So what's the moral of this story? Well, I have 3 smallish children, and I'm now even more of a tyrant about good grammar. Thanks very much indeed.
Charlie, thank you very much. Ladies and gentlemen, I'm Alex Troup, and I'm here to tell you about a case called Bewick and Saxton, which is a decision of our local Chancery judge here in Bristol, His Honour Judge Matthews, which was handed down in May of this year. My colleague Christopher Jones represented the successful claimant, and he would have been the obvious person to tell you about the case, but his successful litigation practice is so very successful that he's currently involved in a 3-day trial, so he's not available. So I've been called off the subs bench to tell you about the case instead. Next slide, please. So there are 2 alternative titles to my talk. The first of which is When Estate Planning Goes Wrong, because this case involved a piece of estate planning which went horribly wrong and ended up in court, which is where no estate planner wants to end up. But this time not because the advisors got their tax advice wrong, but instead because the relevant forms were completed incorrectly, which meant that their effect was uncertain. The other alternative title to my talk could have been A Revision Guide to the Law on the Valid Constitution of a Trust. I use the word revision here because, as you may know, His Honour Judge Matthews used to be a law lecturer at the University College in London, and appearing in front of him can sometimes feel like undergoing an exam in the law of trusts. The particular branch of the law of trusts which we're concerned with here is the valid constitution of a trust, i.e. the essential question was, did the incompletely and incorrectly completed forms constitute a trust? Next slide, please. So, turning to the facts of the case involved a mum and a dad who had an adult daughter who was their only child. And back in 2014, so 6 years ago, the mum and dad took advice from an independent financial advisor who advised them as follows. Firstly, he advised that mum and dad should each purchase an offshore bond for £325,000, that being the relevant nil rate band threshold at the time. Secondly, the bonds would be settled on discretionary trusts for a class of potential beneficiaries, which included the daughter. And thirdly, he advised that mum, dad and the daughter should be the 3 trustees of the trusts. So far, so good. Next slide, please. Now, what actually happened was that the trust documentation was not filled in correctly. Mum and dad signed the application forms for the bonds, and they enclosed cheques for £325,000, and the bond company duly issued the bonds to them, so no problem there. But as regards the trusts, mum and dad signed standardised trust forms, which were forms that invited the person completing them simply to tick the relevant boxes. And those trust forms stated that the trust would be governed by English law, which was why the case ended up being heard in Bristol rather than offshore. And they named mum, dad and the daughter as trustees, which is all well and good. But the problem was, firstly, there was no date stated in the trust forms, so it was unclear when the trust was actually meant to start. Secondly, the details of the bond were missing. The form anticipated that the reference number for the relevant bond would be inserted in the form, but it was not. And thirdly, the trust form stated that they were deeds and the signatures of mum and dad were duly witnessed, but the problem was that the daughter's signature had not been witnessed. So those problems arose in 2014 when these forms were badly completed, but nobody noticed them for about another 5 years. And then suddenly when they were noticed, it prompted the application to court. Next slide, please. It's fair to say that His Honour Judge Matthews was not impressed by the quality of the trust documentation and the way it had been filled in. He said, "I have to say that, given that the matters which I have set out above are not everyday corner shop transactions for pennies, but life-changing estate planning exercises which involve hundreds of thousands of pounds, I am not very impressed with the documentation supplied to the claimants or the way it has been handled. Indeed, the one-size-fits-all tick-box nature of the forms and the unduly formalistic and legally ignorant approach of the professionals involved are profoundly worrying." So you have been warned. Next slide, please. So, against that background, the question which the court had to grapple with, the exam question, if you like, was whether, on the facts that we've set out above, trusts were ever constituted of the bonds which that company issued, and if so, who were the trustees? Now, that's not just an interesting academic question. It had profound implications for this particular family, because if the trust of the bonds had not been constituted, the bonds would form part of Mum and Dad's estate when they died, and they'd be accordingly liable to inheritance tax, which undermined the whole purpose of the estate planning exercise that they had embarked on back in 2014. Next slide, please. Now, the answer to the question that had been posed depended in part upon the proper construction of the trust forms, and the judge made the point that the same principles which govern the construction of commercial documents, which the Supreme Court confirmed in Marlian rulings apply to wills, as you've heard in Charlie's talk, also apply to the proper construction of trust instruments as well. And so the same key passage that Charlie quoted to you in his previous talk was also quoted by His Honour Judge Matthews in this particular judgment, and that was the approach that he took in construing the trust forms. Next slide, please. So applying that approach, the court addressed the three defects in the trust forms as follows. Firstly, does the missing date matter? Answer, no. The judge said a failure to express the date on which the trust is constituted is not fatal to its validity. It is sufficient that it was constituted. Here, it is clear that the applicants, the claimants, or as I've called them, Mum and Dad, intended that their bonds be subjected to a trust as soon as issued. Accordingly, if the trust was properly constituted on or shortly after issue, that is the date on which it takes effect. Next slide, please. Secondly, did the failure to identify the bonds in the trust forms matter? Again, no, said the judge. He said, it is not necessary for the validity of trusts that the numbers be inserted, as long as the relevant property can be identified from the circumstances. I had to consider just this point in another case recently, Armstrong and Armstrong. Now, Armstrong and Armstrong was a case, actually, can we stick with that previous slide? Thank you. Armstrong and Armstrong was a case in which my colleague Nick Pointon, who you're about to hear from after my talk, was involved. And that was a case where a settlor had filled in a trust form intending to settle another financial product, that time a life insurance policy rather than a bond, on trust. And the problem in that case was that the trust form did not identify the life insurance policy by writing its reference number on the form. But His Honour Judge Matthews held in Armstrong and Armstrong that that didn't matter. He held that if the settlor applies for a financial product and at the same time fills in a trust form, it is obvious that he intended the trust form to relate to the financial product he had applied for, even if that financial product is not specifically identified in the trust form. The judge compared it to the situation where a settlor hands over banknotes to a trustee and says, "You will hold these notes on trust for my daughter." And the fact that the settlor does not identify the banknotes by reference to the serial numbers that are written on banknotes does not matter. And the same applied here. Next slide, please. Thirdly, did it matter that the daughter's signature hadn't been witnessed? And the answer was no. Before I read the quote, I just want to put this in context. The trust in this case related to a bond, which is personal property and obviously is not land. And so the formalities set out in section 53(1)(b) of the Law of Property Act for a valid declaration of trust regarding land simply do not apply. And therefore, a trust of the bond could be declared orally. It didn't even require writing, let alone to be in a deed. So if Mum and Dad had simply intended to declare a trust of the bonds with they themselves being the two trustees, there would have been no problem. They could have done that orally, or they could have done it in writing, and there was no need for any deed to be executed. But their intention in this case was slightly different, because they had intended that not only they, but also their daughter was going to be a trustee. Did that mean that their daughter's signature had to be witnessed to make the form a valid deed? Answer, no. The judge said, under section 136 of the Law of Property Act 1925, a shows in action, such as a bond of this kind is, can be assigned at law to a third party if it is absolute and in writing under the hand of the assignor, and express notice in writing is given to the debtor. It is therefore unnecessary for the assignment of the bond to the trustees to be made in a deed. Signed writing will do. So the absence of a witness for the daughter's signature was, on any view, quite irrelevant. Next slide, please. In fact, the judge went one step further, and he held that even if there had been no valid assignment of the bond to mum, dad and the daughter as the three trustees, the trust would nevertheless have still been validly constituted. He said this, on the assumption, contrary to what I have held, that the assignment to the other trustees was ineffective, nevertheless each of them executed a deed of trust intending to subject the bond to the particular trusts in favour of third parties. In the circumstances, even if there were no effective assignments to the other trustees, the trust would still be completely constituted with that applicant as trustee, although if it was still desired to appoint the other person's trustees, that would have to be carried out later. And in support of that conclusion, the judge relied upon this case called T. Choithram International against Pagarani. Now, that was an interesting case where a very wealthy gentleman who was on his deathbed decided that he wanted to give his shares, which were worth an awful lot of money, to a charity which he had set up, of which he was one of the trustees. But he didn't effectively transfer the shares to the trustees at any time prior to his death. And so the question was the trust of the shares validly constituted? And that went all the way up to the Privy Council, who held that the trust had been validly constituted, even though there had been no transfer of the shares to the trustees, because the testator was a trustee himself, and it would have been unconscionable for him to resile from the gift. So the same applied here. If the assignment was ineffective, mum and dad would still have held the bonds on the discretionary trust set out in the trust forms because their conscience would have been affected. Next slide, please. So all three problems were solved either by construing the trust forms or by applying basic principles of trust law. The claimants had made an alternative claim based on rectification, but it was held that that claim was unnecessary and the judge didn't have to deal with it. Next slide, please. So the answer to the exam question which was posed was, firstly, yes, the trusts of the bond were validly constituted, and the trustees were mum, dad and the daughter, because the bond had been validly assigned to them in accordance with section 136 of the Law of Property Act 1925. Next slide, please. So what can we learn from this, apart from the case being a useful reminder of the legal principles of the construction of trust documents and the valid constitution of trusts? Well, it seems to me that there are at least three practical lessons you can take away. Firstly, this is a cautionary tale. Beware of the standard trust documentation, which needs to be completed simply as a tick box exercise. If at all possible, use your own bespoke trust documentation, which is drafted specifically for the task in hand. But if you can't do that and you have to use tick box documentation, for goodness sake, make sure that it is properly and completely filled in. Secondly, if you come across a trust instrument which has not been completed correctly, or there are bits missing, this case shows that a lot of the problems can be cured simply as a matter of construction. The Marley and Rawlings approach to construction invites a robust and common sense approach, and modern judges, such as His Honour Judge Matthews, take exactly that approach in curing the sort of problems that arise as shown in this case. Thirdly, costs. The judgment doesn't record what happened on the issue of costs, but I myself was involved in a trial only last week about the proper construction of a will, and I acted for the claimants. We applied not only for the declaration as the proper construction of a will, but we also applied for a third-party costs order against the will draftsman, and we added the will draftsman as an additional defendant to the claim. The trial came before His Honour Judge Matthews last week, as I say, who granted us the declaration that we sought, and also made a third-party costs order against the will draftsman. And you'll recall that the Supreme Court took a similar approach in the Marley and Rawlings case. So if you're involved in a case such as this, where you are concerned with the proper construction of a will or the proper construction of a trust document, then it might be worth considering applying for a third-party costs order against the draftsman of the trust instrument or the will, because that can short-circuit the need to launch into a separate round of litigation, a professional negligence claim against that person. So, ladies and gentlemen, that concludes my talk, and I'll now pass over to my colleague, Nick Pointon.
Thanks, Alex. Good morning, everyone. Right, while I try to wrestle control of these slides, let me begin, like most lawyers, with a quick disclaimer. We've recently rehomed a rescue dog, a very young Labrador, who unfortunately came with the name Boris. So if you hear me shouting out Boris at any point, I'm not declaring my love of our not so glorious leader. I'm probably trying to stop the dog from chewing something he shouldn't be. Right, I think I've got back control, so off we go. I'm going to give you a very brief overview of some issues that arise where cross-border implications arise in the States. And I'm going to focus on particularly on issues that arise in administration as opposed to issues of succession, but I'll say a little bit about both. That's the first key distinction that I'm going to draw between issues of administration and issues of succession, and I'll say a bit about that in a moment. The second big distinction to be mindful of when advising in these areas is the distinction between issues of jurisdiction and issues of choice of law, and that's the distinction between the question of which country's courts should deal with an issue, that's the matter of jurisdiction, and having resolved that, the question is which law should they apply, the laws of which country should they apply to that issue, and that's the choice of law problem. Now, the distinction between administration and succession is a really important one and often misunderstood one. Issues of administration essentially concern gathering in the estate. That will include the making of grants of representation, the collection of assets, and the payment of liabilities that affect those assets. Essentially, the process of gathering up the net estate ready for distribution. That's when succession kicks in. So issues of succession concern the beneficial entitlement to share in that net estate, essentially who gets what. But that also includes issues surrounding the formal and substantive validity of wills, their interpretation, their effect, 1975 Act claims that might disrupt or displace the provision made by the wills or by an intestacy regime, and even forced heirship regimes, something which we don't have in this country, but which is present in a lot of others, including some continental European jurisdictions, essentially national laws that require a testator to leave at least part of their estate to certain prescribed heirs, usually their children. All of those questions, effectively who gets what, are matters of succession. Now, looking at administration, which is the simpler of the two topics, the English court has jurisdiction to make a grant of representation in respect of anyone, no matter where they are. It's an extremely broad power contained in Section 25 of the Senior Courts Act, but it's usually only exercised if the deceased had property in England and Wales, since there would otherwise be no point in issuing a grant. The main purpose of the grant is to prove your title to that property, enabling the personal representative to gather it in. But theoretically, the power exists to issue a grant in respect of anyone, no matter where they are. When it comes to choice of law in administration, it's relatively simple and straightforward. Issues of administration that concern property in England and Wales will be governed by English law. And that's so regardless of where the deceased was domiciled when they died, and it's regardless of the law which governs succession, the question of who gets what. When we're simply looking at issues of administration affecting property in this jurisdiction, the English courts will apply English law. Succession is more complicated. The rules of jurisdiction and the rules of choice of law in questions of succession are a bit more nuanced. Now, you may have come across the Brussels regulation, also known as the Judgments Regulation, in civil and commercial matters generally. It's the EU regulation that tries to harmonise the rules for determining jurisdiction and the recognition and enforcement of judgments in civil and commercial matters, but it expressly excludes from its regime wills and succession. It doesn't touch that at all. That's because the EU has a bespoke succession regulation that deals with those things and also deals with choice of law rules in succession issues. But to be difficult, we did not subscribe to that regulation. It does not form part of English law, and obviously won't when we leave the EU. So that area is governed by old-fashioned common law rules. Issues of jurisdiction and issues of choice of law in succession matters are governed by English common law. And issues of jurisdiction will be resolved by applying the traditional principles of forum conveniens, which essentially means, is this the most appropriate forum in which to litigate that issue, or are the courts of another jurisdiction better suited to that task? Now, the question of applicable law, the choice of law issue in succession, is a little more complicated still, because you have to draw a distinction based on the nature of the property that is in issue. In respect of immovable property, such as land, it is the lex situs that governs determines the applicable law for disputes over such property, and that unnecessary Latin simply refers to the law of the place where the property is situated. So in respect of, for example, a house in Spain, the lex situs is Spanish law. But if we're dealing with movable property, essentially everything else, it is the lex domicilii that falls to be applied. That is the law of the jurisdiction in which the deceased was domiciled when they died. And that, of course, can change during the deceased's lifetime. And those of you who tuned in last week to Adam Boyle's talk will have been given a run through of the basics of the law of domicile. And if you didn't, I think you can still get that talk by contacting our marketing team. We can send you the link. Now, again, that's the English common law position. That's what applies here because we're not part of the EU succession regulation. That doesn't form part of our law. It can still come into effect in disputes that concern English domiciled persons. It can particularly find application where they own property in another member state, immovable property in another member state, or where they die habitually resident in a member state, and that concept of habitual residence can differ in some circumstances from domicile. So it's something you still have to be mindful of. Now, since this talk is about administration rather than succession, I'll focus a little bit more closely on that and look at some particular rules in the context of administration. So property situated in England and Wales, whether it's movable or immovable, vests in an executor as at the date of death. Or it vests in a administrator as at the date of a grant of administration in the case of intestacy. But assets elsewhere in the world do not automatically vest in the personal representative. That rule only applies to assets that are within this jurisdiction. Where the deceased dies domiciled abroad, an English grant can be taken out in respect of property in England, but that grant generally has no effect in any other jurisdiction. To deal with assets in the other jurisdiction, you need to go and get a grant there, or a foreign personal representative needs to go and get a grant there. And generally, as a matter of comity, the English court will not make orders about foreign assets. It will leave that to a foreign court. There are some very limited circumstances where the English court will make orders about foreign assets, such as where the foreign court has already indicated that it expects the English court to deal with this. And there is a very limited in personam jurisdiction that the English High Court has to deal with foreign assets in cases of judicial administration, but they are extremely, extremely rare. Now, no talk is complete without a bit of case law, so we'll look at a few cases very quickly that exemplify some particularly niche rules in this area. The priority of creditors, so a matter that the administrator needs to deal with when paying the liabilities of the estate. The priority of creditors, regardless of where they are in the world, is governed by English law. So when an English administrator is dealing with English assets, the priority of creditors is governed by English law, and foreign creditors are treated exactly the same as domestic ones. But that entails the consequence that English laws of limitation apply to those debts, those claimed by creditors. And that means that a debt can be statute barred, and so doesn't fall to be paid by an English administrator, as a result of English limitation laws, even if the debt would not have been statute barred under the law of the country in which the deceased was domiciled at their death. So quite a peculiar rule, but it exemplifies how English law governs those questions of ascertaining and paying liabilities in an English administration. Now, particularly niche rule, if a foreign personal representative dealing with assets and liabilities in that jurisdiction thinks they wrapped everything up and they transmit the balance of assets to an English personal representative, but in fact they haven't yet paid all claims that fall due under that foreign law, the English personal representative has to administer that portion of transferred assets according to the law of the country in which they were collected. So in that niche circumstance, the English administrator is not applying English law to those assets. He effectively has to finish the job of the foreign personal representative according to that foreign law. And it's an example of the English court's approach to comity. It says, well, English law applies to the English assets and that administration, foreign law applies to the foreign assets and that administration, and that remains so even if the foreign personal representative fails to complete their job. We will require the English personal representative to effectively finish it off for them. Now, those principles are, albeit a little complicated, are more straightforward dealing with monetary assets, getting in assets of monetary value and paying liabilities, debts of monetary value. But it can become very complicated when we look at more inchoate assets, such as rights to confidential or privileged information that form or may form part of the estate of the deceased person. When the administrator is trying to exercise those rights or gather in those rights for the benefit of the estate, issues can become far more complicated than I can go into in this talk, but it's a shameless opportunity for me to plug a reference to the Hennessy case, in which I've been involved for the last few years, looking at those issues and some of the ones I've already canvassed in this talk in the context of the fraught administration of the last patriarch of the Hennessy family, who died domiciled in Switzerland about 10 years ago. There's still all manner of legislation looking at, all manner of litigation looking at the powers of administrators in different jurisdictions to gather in certain inchoate assets, such as privileged information. So to summarise that whistle-stop tour, if you like, through those areas, if you are an English administrator in an estate that involves property in different jurisdictions, you get an English grant for the English assets, and foreign personal representatives can get a foreign grant for assets in other jurisdictions. You collect in and pay, you collect in those assets and you pay those liabilities in accordance with English law, the law governing issues of administration of property in England. And having done that, you distribute to beneficiaries under the law governing succession, which will depend upon the nature of the property, whether it's immovable or movable. Or if you are not the principal administrator, if the English administration is simply a sideshow to an administration that's focused elsewhere, you can transfer the surplus, the balance left when you've paid debts, to the principal personal representative in another country. Or if there's any ambiguity about what you should do, or if beneficiaries are threatening to kick off if you part with money to anyone but them, you can always seek directions from the English High Court, having first consulted the friendly and helpful barristers at St John's. The High Court is extremely willing to offer its guidance, particularly in cross-border cases, because it appreciates how intricate and complicated some of these rules can become. So that's a very brief whistle-stop tour through that, with no interruptions from Boris. So that's all to the good. I'm going to pass you back now to Matthew.
I would simply convey my thanks to the four speakers for the talks, which I personally thought were very interesting. And as I said at the outset, I think those are issues that are applicable to both contentious practitioners like myself and non-contentious practitioners. We haven't as yet had any questions in the Q&A box, but to give people a few more minutes to potentially raise any questions. One from me really, I think certainly the last three talks at least picked up on the possibility of placing matters before the court for directions, be it construction or whatever that may be. And I wonder if any of the speakers had any practical tips and thoughts as to when a PR should do that, what steps they should take before doing so in terms of consulting the beneficiaries, and just any thoughts generally on the usefulness of that as a mechanism.
Well, I'm happy to start because the case that I was involved in, it involved those issues exactly. 15 separate defendants, 2 sets in effect, neither of which could agree about the proper interpretation of the will in question. And so the way that the executors addressed that problem, quite simply, in the first instance, was to canvass the views of the beneficiaries as to what the proper interpretation was, and attempt to ascertain whether or not an agreement could be reached. And in truth, they got quite far. And so it was almost the case that, that the matter was resolved without an application to the court as to the proper construction of the will. But at the final hurdle, the beneficiaries decided that they couldn't agree on the proper allocation of the assets under the will, and so we went off to court. But there was certainly an extensive exercise conducted by the executors trying to reach an agreement or facilitate an agreement between all of the potential beneficiaries. And once that exercise had been exhausted, it was only then that the application was made to the court.
Could I perhaps come in on that as well? 2 practical things that have occurred to me when I've been involved in applications to court. One is that in terms of costs, the general rule in re Buckton and cases like that is that where you're going to the court because a tricky question has arisen and there's disagreement as to what the right outcome is, the general rule is that the cost will come out of the estate. And if you want a different order, you're going to have to fight against that. And if you're going to go down that road, then you have to make sure that you've teed that up in pre-action correspondence. So you've given everyone a chance to say what they think the answer to the problem is. And if you think that someone's acting unreasonably, you've said to them, I think you're acting unreasonably, you've explained why, and you've given them a cost warning, so that when you get to court, that gives you the grounds to argue that re Buckton should be departed from. The alternative, of course, is to do the third-party cost order of the type that I mentioned in my talk. The other thing that has sometimes worked in cases I've been involved in is that where you are acting for a trustee or executor and you're putting a question before the court, sometimes you can get out of the litigation effectively and leave it to the warring parties to battle it out at court. So in some of the cases I've been involved in at the CMC stage, we've sought a direction that the trustees or the executors, having put the matter before the court, can then step back and actually not even attend the trial, let the warring beneficiaries battle it out, and the trustees and executors themselves can simply wait to hear the result. So that in some cases can lead to quite a significant cost saving.
Great, thank you both. That was very helpful. We have had a question which I think is probably directed to Nick, and the question is as follows: where a husband and wife are both domiciled in France, are you able to claim the first to die's nil rate band? I think that's probably one for you, Nick.
Yeah, I'll jump in on that. Thanks, Matt. The answer, as with anything that pertains to tax, is it's complex, but the likelihood, if the husband and wife are domiciled in France, they're probably also resident there for tax purposes, which means it's likely that the French tax regime will govern most, if not all, of their estate for tax purposes. But if there is still property in the UK, or if they are, if there's immovable property in the UK, or if they're not deemed resident in France for tax purposes, then there may still be a liability to English IHT. Insofar as there is, you can usually avail yourself of the nil rate band that you would enjoy if you were domiciled in the UK, generally. But it does depend on the particular circumstances of each case. There is a double tax treaty in place between the UK, or England and Wales, and France to level out, if you like, the treatment of both systems. But it is very likely, if they're domiciled in France, that they are treated resident there for tax purposes. So you will need French advice on the impact of French IHT in those circumstances.
Great, thank you, Nick. No further questions. Emily. Sorry, you're quite right.
Sorry, there just one question's just come in.
Yeah, thank you. I've just seen that. So I think it's another one for you, Nick, I'm afraid. If a client currently domiciled in Scotland only had movable assets here and immovable assets in Scotland, can they still obtain a will in both? The client intends to remain in England for now. Does that make sense, Nick?
Well, I can hopefully say something of use about it. In terms of a will, it's perfectly possible to make a single will that governs all assets on the planet, wherever they may be, or to create separate wills, very clearly delineating the assets that they each relate to in different jurisdictions. The English approach to the validity of wills that affect assets around the world, or assets that are, the validity of wills that relate to assets in other jurisdictions, is an extremely generous one. It will validate a will if it complies with the laws of that jurisdiction, this jurisdiction, in the interest of upholding the will. So it's perfectly possible to have one will dealing with assets in the UK and in Scotland under the same document. If you intended to refer to obtaining a grant in both jurisdictions rather than a will, you would need a grant in both jurisdictions, one to deal with the assets in England and Wales and another to deal with the assets in Scotland, even if they are movable assets up there. So I hope that answers both possible permutations of the question.
Thank you very much, Nick. Okay, in the absence of any further questions, unless anybody on the panel has anything they'd like to add to the questions that Nick tackled, I think that probably brings the webinar to an end. So thank you once again for the speakers. Thank you for those behind the scenes helping us out with the technical aspects. I hope all of you attending found that useful and enjoyed it. And as I say, the video and the notes will be circulated shortly, along with the feedback forms. And we'd be very grateful if you could please fill those in and return them for use on future webinars. So thank you very much all again, and I hope you all have a good day. Thank you.